Well, welcome everyone. We are law partners, but we're also sisters. So 3 years ago, we decided to open our own law firm together. And we always, at the beginning of presentations, tell people we're sisters, because when we first started doing these presentations, our mom came and was sitting in on them and sitting in the back, and she'd be, "Tell them your sister." And finally we're like, "Mom, what?" And she said, "Tell them your sisters." So now at the beginning, we put that out there. And also it helps to explain because we interrupt each other and talk over each other. And when they know we're sisters, they go, "Oh, they've been doing that their whole lives." So it makes it understandable. But it also, I'm going to continue to talk here. It shows that it's
the
important.
older sister. Can you tell?
It just shows we understand how important family are in these situations, and I think that might be why it kind of drove us to this area, is just because we put a lot of importance on families.
So here are some of our learning objectives for today. And just to explain why you guys can all hear us just fine, but they are recording this for people who weren't able to attend. So we're going to be moving the microphone back and forth just so you understand why. Our objectives today are to understand the importance of advanced planning and of having the opportunity to involve the person with dementia, to identify the steps to getting legal, financial, and future care plans in place, to become familiar with specific legal issues, future care options, and financial issues pertaining to dementia, and to provide hands-on tools for making plans now.
So we're going to skip over the video.
So we think planning early is crucial, and by planning early, as our focus is, while we do all kinds of estate planning, we do a lot of elder law planning. We also do special needs planning, but also just estate planning for all families. We really think to some degree elder law planning starts when you're 18. I mean, we really need to be thinking of things that early on, and we think the things that we're talking about are stuff that people should start talking about with their kids when they're graduating high school.
And in some ways, you're doing your children a good service by talking to them early, because often these things aren't talked about until issues like dementia come up, and then it's really a difficult topic.
And to some degree, that also goes to where we know sometimes people almost get, I don't want to do this planning yet because by doing this planning, I'm admitting there's a problem. So I'm just going to keep not really dealing with it. We think everybody should be doing it because we never know what could happen to any of us. And frankly, something we often see is even where we have caretakers taking care of a loved one, sometimes it's the caretaker who ends up getting sick. And if they don't have their plans in place, there can be issues as well. So this is a good time for everyone in the family to be updating their plans.
And dealing with issues of dementia, it does give the person who has dementia an opportunity to decide what they want to have happen and who they want to make decisions for them when and if they're unable to do so. So part one, the legal issues. So the goals of legal planning are, one, to make plans for health care and long-term care. Long-term care often meaning in an assisted living or nursing home, or they refer to it as a skilled nursing facility. To make plans for finances and property, and to designate, as I said, to designate someone who's going to make those decisions when you're no longer able to.
We think it's important for people to be able to make those preferences when they're still able. That's things like filling out, having a healthcare power of attorney, where you're saying who you would want to make decisions and then using that as an opportunity to speak with that person about what your wishes are. Families, members, and healthcare providers should have copies of those documents, and we're going to talk more about the durable power of attorney for healthcare and the living will. Legal capacity. Now, this is always a issue we get questions about. If somebody has been diagnosed with dementia, can they still sign these legal documents? Well, it's going to vary. It really is. A lot of the times, especially if it's early after a diagnosis, yes, they're still able to sign those documents. And frankly, sometimes that changes. Sometimes we'll have somebody who is able to answer the type of questions to show that they have capacity to be able to identify who their loved ones are, what assets they have, the type of key questions that we use to determine if they have competency to sign a document. Sometimes later in the same day, they may not. And I think if you have a loved one who is dealing with dementia, you may see that, where that can change throughout the day. And so sometimes that's a matter of today may not be a good time to have these discussions or to sign these documents, but it may be possible to do another day.
And we'll often, when we're working with clients, particularly either much older clients or people who have memory issues, have dementia, have Alzheimer's, we'll just say, look, this is when we're making an appointment to sign these documents with these wishes that you've let us know. If it's a bad day, call us and we'll reschedule, because it really does. Capacity can be a very fluid concept, and sometimes people may have a lot more lucidity than other times.
Again, we really like having these, and first we're talking about the durable power of attorney or a financial power of attorney. This is the opportunity to say who you would want to make decisions for you if you're not able to do so. When we're doing, and I'm sorry, it says durable powers of attorney, and we have both the healthcare and for finances as well. These documents are so crucial because when somebody does not have these documents in place, if it gets to the point where they're no longer able to advocate for themselves and make their wishes known, that's when we're sometimes looking at having to get a guardianship. And that can be a really onerous process, and it's a very long and ongoing process with annual or biannual reporting for the rest of the life of that individual. In Ohio, the preference really is to use these type of documents because that gives us the ability to make our decisions about who we want to make those decisions for us. But again, those have to be made when we still do have that capacity to sign.
And this last point, these need to be created in accordance with state law. State law is what rules have to do with wills, have to do with powers of attorney. So if someone has a power of attorney from when they lived in a different state, it may not apply here. Often there's some reciprocity that's given, but if someone is living here in this state, they ought to, if possible, have a power of attorney from this state or from whatever state they're living in.
But before we move on from that, this is another area and that we think if you're looking to have these documents done, there are some state statutory documents for these that you can find. Sometimes hospitals will hand out statutory healthcare powers of attorney, and there's similar documents. But if you're dealing with these issues, it's probably worth reaching out to and talking with an elder law attorney. Because as an elder law attorney, we put different things in our powers of attorney than folks who even just go to a standard estate planning attorney. And if you don't have those documents in place and you get to the point where maybe you're needing to do some Medicaid asset protection planning, you're going to try to save some assets because you're anticipating needing to be on, the loved one needing to be on Medicaid. If you don't have specific powers allowing some of those key planning options in that power of attorney, you may not be able to do it. So it's an important thing to make sure you talk with an attorney and let them know that that's something you're concerned about to make sure they're able to help you with that.
So the living will is, it states what a person's choices are for future medical decisions, such as the use of artificial life support. And this is, it says here, it's when a person is irreversibly ill or critically injured and near death. In Ohio, the terms that they use are a permanently unconscious state in which there's no likelihood that the person will regain capacity, or if the person has a terminal condition. And the way that they define terminal condition is that it's not the person has stage 4 breast cancer and they have a year to live. It's the person has stage 4 cancer and they have days to live. That's when this document will come into place. And it says what you want. Do you want measures to be taken to preserve your life, or do you want to say, I want to be made comfortable and let things take their course? But it allows you to make that decision. And it's important because sometimes what we'll see is Perhaps one child is saying, no, I know mom would want us to do everything possible. And another child saying, no, mom would want us just to make her comfortable. And it can cause a lot of discord. This is a way of letting the person say, no, really, this is what I want, whatever that is.
Well, and this is we have a lot of meetings with families where we sit down and we're going through all of this planning. And this can be a really interesting part of the conversation, because sometimes you'll have one person say, I want a last will, I want to be made comfortable, but if there's a living will, I want to be made comfortable, but if there's no chance for me to recover, I don't want to be kept alive, on machines forever. And the other person says, well, I couldn't do that. And the person says, all right, then I'm not naming you, and they name somebody else because they know what their wishes are, and they don't want to make it hard for somebody who it would be difficult to make that decision. They're going to make sure to pick somebody who will do what they want them to do.
So a will. A will is, in the state of Ohio, and really in just about any state, if you don't have a will, the state of Ohio has determined how your things will be distributed. It's called the laws of intestacy. So if you want something other than what the state says, you need to put it in writing, and it needs to be in a will. It names who the executor and the beneficiaries are. The executor would be the person who kind of takes care of getting everything distributed and all the debts paid. The beneficiaries are the people who would, and people and organizations who would benefit from your estate.
One of the things that's really important also for people to think about, some people say, you know what, the state would just give it to my wife and my kids, I don't care, that's fine. I don't need to do any other planning than that. But sometimes you do for other reasons. For one thing, if you have stepchildren, it's very state by state. In some states, a stepchild is going to be treated the same as your own child. But in Ohio, you could have a stepchild who you've raised since they were 2 years old, and they really are your child in your heart. If you do not do planning to name them in your will, they will not inherit until you have no other fifth cousins. That's the only time they would inherit. So if you have stepchildren you want to take care of, you need to make sure you put a will in place. The other thing also is naming who you want to be your executor. There's some really important things that happen with that. You can say, I want somebody to be my executor, and they can serve without bond. That means they don't have to pay money out of your estate to get an insurance policy. It's a way to save funds so that your family will get the full effect of what you're trying to do for them.
The other point with an executor, for those who have children who are out of state or loved ones who they would want to act as the executor, if it's not listed in a will, the court will not name an out-of-state person to act as the executor of an estate unless it's in the will. And again, it only goes into effect when the person dies. So you think of it, the power of attorney is what is in place before you pass away. The will comes in place after the person passes away.
And this is often a source of confusion, that's funny. Confusion as well, that folks will come in and they'll say, you know what, I'm power of attorney for my mom. My mom passed away, and I went to the bank and told them I was power of attorney, and they said that they can't use that document anymore. And it's true, because a power of attorney is only in effect when somebody is alive. It's when they pass away that it goes to the will and the executor, and you have to go through probate. That's where a good thing to be thinking about is also, you can use wills, you can use trusts, but folks also may want to look at bank accounts, making sure if they have a spouse, that the spouse is a joint user, so that when the first spouse passes away, the second spouse doesn't have to go through probate. They're able to just get those access to those funds. And folks can also do a transfer on death beneficiary with the bank. But again, that all has to be done when the person is still alive.
So a living trust, often you'll hear it called a revocable living trust. And what that is it first of all, it names a trustee who can take care of the property that's put in it. It provides instructions of how to manage a person's estate. It can include a broad range of property. avoids probate, and it specifies whether a trust will end when the last beneficiary dies or to continue to benefit others. So kind of how I like to think of a trust often is it's almost like it's a basket that holds anything that you title or put into that trust. And you, as the creator or grantor of the trust, say, this is what I want to have happen to these things that are in my trust. This is what I want to have happen when I'm alive, if I'm incapacitated, and this is what I want to have happen when I pass away. And so long as you have capacity, a revocable living trust, you're able to make changes. You can change beneficiaries, you can put things in the trust, you can take things out of the trust. It's when you pass away that it's kind of, that's when the rule book gets, it goes from being written in pencil to being written in ink. And what you say in there at that point is what the trustee will do to put into effect. Again, it avoids probate. Wills will say what they want to have happen, but it has to go through the probate court, and it's a very public process. Trusts are private, and they don't need to go through the court system. It just says what they want to have happen.
And what we mean by a public process, and some of you may know this if you've had a loved one who's gone through probate. If when a person passes away, and if they're either have only a will or they don't have a will, and it's going through probate, it's a very public thing in Ohio. If your neighbor passed away 5 years ago, you can go onto the court's website, see what they owned when they passed away, who inherited it, what debts they had when they passed away. And unfortunately, sometimes people troll those websites. And so if somebody is inheriting some funds, then they may get calls from people who have great investment ideas. By doing things like using revocable trusts, various trusts, or by doing transfer on death beneficiaries, that's where we can keep that out of the public eye, and it's a way to help protect our loved ones. So, making choices as a care team. This is so important. This is a way to include the person with dementia as much as possible so that they're able to make their wishes known. That ongoing communication is important. Needs change, what somebody wants is going to change, and what is realistic changes as well. When there are disagreements, when sometimes it does unfortunately reach the point where the person with dementia is not able to be a good advocate for themselves anymore, that's when we may have to look at other options, including mediation or guardianship.
So guardianship, it says here that it's sometimes called conservatorship. Here in Ohio, they're two separate things. Conservatorships in Ohio, people have capacity, but they're physically infirmed, and they say that this is the person that I would like to make decisions for me under the court supervision. Typically, when we're looking at people with dementia, we're talking about guardianships. And it's declared by the court, appoints a guardian to assume total responsibility for the person. And again, a diagnosis of dementia alone is not sufficient, that there has to be capacity issues and whether the person can make decisions and take care of themselves. And here in Ohio, there's two different types of guardianship. There's guardian of the person and there's guardian of the estate. I don't think these are in your documents, but guardian of the person has to do more with the day-to-day decision-making for the person. Doctors, where they're going to be living, all those types of issues. Guardian of the estate has to do with financial. So in some ways, it's somewhat analogous to the guardian of the person, is somewhat analogous to the healthcare power of attorney, and the guardian of the estate is somewhat analogous to the durable power of attorney, that financial power of attorney. But it's all under the eye of a judge. And one of the, everything has to be approved. So if you want to, in theory, anything that you buy for that person, you have to go to the judge and ask for a request for funds to be distributed for this, that, or the other thing. So, which it's good because in some ways, because some people can be taken advantage of, and it's a way to avoid that, but it is a cumbersome process.
it's not unheard of for a situation to happen where you may have a couple who everything's joint, they own all their assets together, they own the house together, they may have a good amount of funds, and they're able to make their decisions on a regular basis. If they haven't done their planning and all of a sudden we need to go to a guardianship, well, all of that information, again, is going to be on the public website, it's going to be going before a judge, and you may have the well spouse literally having to go to the judge to say, this is what I want to spend on my spouse. Who would think they would have to go to ask a court for that decision? Or to spend on themselves, or to spend on their kids. But half of their assets are for the spouse who may no longer have capacity, and a court's going to have to make those decisions. So that's why doing these power of attorney documents is so crucial.
Well, and just an additional point with that is the court may or may not pick the person that you would pick to be the guardian for you. So if you want, and what we have in all of our power of attorneys is that if most of the time you should not need a guardian if you have a power of attorney. There's occasionally that you will need one, that it comes up. But we have in our documents, for example, if I should need a guardian, I want the person that I've named here to be my guardian. And because sometimes the person, as I said, the person that you think would make the good decision may not be who the judge picks. Importance of legal planning for all couples. It's particularly important if there's a couple that aren't married. Now here they say same-sex couples now can marry, so same-sex couples that are married will have the same rights as any other married couple, but same-sex couples and domestic partnerships that are not officially married, you're going to want to have documents that allow that other person to make decisions, because otherwise they may not have access to you if you are become incapacitated. So again, legal tips for unmarried domestic partners: have copies of legal documents easily accessible to both of you. I think that's good advice anyway, to make sure that that those documents are in a place where people know where they are. Bring copies of legal documents when traveling. Complete a hospital visitation authorization form if necessary, and make your wishes and documents known.
What we actually do, what we recommend with our clients after we've done planning, is there's a company we work with called Legal Directives, and they'll actually, if our clients agree to this, we get a little plastic card, kind of looks like a Costco or a Sam's Club card, and it has your information on it, and it has a phone number, and we will send in the healthcare planning document. So that healthcare power of attorney, a living will, and we even do a HIPAA release form where you list other people who could have access to if you were in the hospital, who would be okay for the doctor to give information to. And then you get this card that you carry in your wallet all the time. So if you're out of town and you're on vacation and something happens, you can easily, 24 hours a day, 7 days a week, get access to those documents. And that's something that anybody can get. You can go to legaldirectives.com and you can get that card. We think it's a great idea, and we got it for our mom.
So what do you want to do to put your legal plan in place? First of all, gather your existing documents. Many people have documents, although when they look at it, they leave things to their kids, but they're also listing, who the guardians are they want for their kids, and their kids are now 50, and so it might be time to update that. Determine what documents need to be updated or created. And besides the will with the 50-year-old children, is a lot of times, particularly the financial power of attorney, banks may not take those once they're a certain number of years old. Often we're hearing around 5 years old, banks may or may not take them. So we typically say every 3 to 5 years, look at your documents. Do they still reflect what you're thinking? And maybe update particularly that financial power of attorney, because at some point, all of us may not have the capacity to execute a new document, and it's much easier to argue over one that's 4 years old than one that's 24 years old.
And the law changes. Over time, the law changes, and in 2012, there were major changes to the Ohio durable power of attorney, and all of a sudden, new things had to be specifically stated, or you weren't going to be able to use those documents. I can't tell you the number of people who come into our office and say, we're good, we have a durable power of attorney already in place, and you look at it, it is so old that it doesn't do what they think it would do. So that's just another reason to make sure you're keeping that up to date as much as you can.
You can do it yourself. There's online, there's office supply stores. Of course, we think that you should talk to an attorney. I think attorneys know a lot more than what those things have, but they're better than nothing. And the state, frankly, you can go online and get state statutory durable power of attorney, living will, healthcare power of attorney. So those are all, if you're going to go online, go to the state of Ohio and look for the statutory, make sure it says that they're the Ohio statutory, because you don't want something that was drafted, in California that may not apply, may not have Ohio law in it. Find assistance, there's the helpline. NALA is the National Academy of Elder Law Attorneys. They have a lot of information on their site, and they also have lists of attorneys, and then law help. Is that it for that one?
All right, so we've got
Okay.
a break while Cynthia changes that. What kind of question do folks have at this point?
So if you have the living will and the DPA, then you really don't need to do the guardianship, or you really should just...
For the most part,
Repeat the question.
so she was asking if you have the power of attorney, if you have a living will, it shouldn't be necessary to get a guardianship. Yes, in most cases. So in Ohio, the courts are going to look for the least restrictive option. And always the guardianship is the most restrictive option. So if you have a power of attorney, most courts will take that and not have a guardianship. We have seen issues like, for example, we had a client who had power of attorney for her father. Father had dementia, and father was, I believe he was a postal worker, and he had a pension with whatever the postal worker's pension is, and they wouldn't take a power of attorney. So she ended up having, and she couldn't get any information about her dad's pension, and she ultimately had to get a guardianship so that she could deal with the federal pension. So that's a case where it may not, you may still need a guardianship, but typically not. And to that point, once we found that out, we started putting in our own powers of attorney. We found that it was similar to, for example, people who had OPERS or STRS, the teachers, that they said, yeah, we won't take it unless it specifically mentions STRS, we won't accept it. So we've started putting in specific language. We always ask, are you on one of these pensions? And if they say, yeah, we include that language.
So to the extent somebody is going to just go ahead and get the statutory forms we were talking about, there are some places on there where you could write in specific additional instructions, and that's something somebody could add in. If we're dealing with an STRS pension, and even if it's dad was the teacher, you'd want it both on mom and dad's, especially if mom might at some point be eligible for those benefits. So that's a good thing to include for both of that.
Yeah, I have a question going back to trusts. For example, and this is a hypothetical here, if the husband and wife have joint trust and the husband dies during the time that the wife is dealing with Alzheimer's, how does that relate to, say, the person who now has power of attorney? Can they...
It's going to vary based on how the documents were drafted. So first of all...
I can see so much difficulty with trusts in this.
Well, yes and no. In some ways, I would argue trusts may be a better way to deal with it. First of all, often what we're seeing is people are naming the same person as their power of attorney and backup power of attorney that they're naming as their trustee. So it's the same person. Where we were talking about sometimes places aren't going to accept documents that are more than 5 years old that are power of attorney documents. So you may have trouble at the bank when you bring in that power of attorney document. If you're the trustee and you're dealing with trust assets, that's a whole different relationship, and you're going to have likely less problems with an older trust document with an active trustee who's involved than you may with the power of attorney. Now, as far as if there's a conflict, I mean, again, typically we have the same person named in those roles, and sometimes you even specifically reference the other, that my power of attorney has the right to edit my revocable trust. Or not. Maybe you don't want them to do that. But that's a discussion you're going to have with the attorney to make sure your wishes are reflected.
And they're different roles in some way. So the trustee will only be able to deal with whatever property you have titled into that trust. So, but for example, let's say dealing with the utilities, dealing with a landlord. The trustee isn't going to be able to necessarily deal with the landlord. The power of attorney is going to be able to do that.
Even if the power of attorney is not named in the trust.
Yeah, because the power of attorney deals with anything that's not in the trust, while the trustee you've only given.
I'm saying that the one trustee is deceased. Mm-hmm. The survivor has Alzheimer's.
So what typically what we have then is a successor trustee. So if the person passes away or no longer has the capacity, mm-hmm. someone else who you've named then steps in to act for that person.
Would that person have to be in the trust or named in the trust?
They would be named in the trust, but oftentimes there's kind of procedures put into place for how you name a trustee. So if there isn't someone who's serving in that capacity, you could say how you would want that role filled.
So for example, our mom has a trust, and she's given us permission to use her as an example. And she has named me as the primary trustee.
Because she doesn't like her as much
I know.
as she likes. So she's going to have to do all the work.
So I'm the primary trustee, but if something happens to me, if I move out of state or if I'm not around any longer, Chris is the backup trustee. She would be the one who would be able to, or if I become incapacitated, she would be the one who would be able to do that. Now, what you may often have is, and this is up to people's individual choices, my mom could have put in the trust that I'm to serve as trustee, but if I'm no longer able to serve as trustee, I can name my successor. She trusts me. She knows I'm going to take care of her so that if I need to, I can name someone else. And another thing we actually do is in our trust documents, we give the individuals the right to appoint a co-trustee. So maybe I'm serving as my mom's trustee, but there's a lot going on. She's got gazillion dollars because she got the winning lottery ticket, and we're all really happy about that. That's not true yet. Maybe it would make sense for me to get a CPA to serve as co-trustee with me. I can do that. Or I could get a financial advisor to serve as co-trustee with me. But that's because that's how those trust documents are drafted. It's really going to be individual based on who drafted those.
And in this example of Dawn's, that, she's the successor trustee for our mom, and she could pull someone on to help her. When she was no longer serving as trustee and I stepped in, that co-trustee doesn't automatically stay on. They fall away, and I would be the trustee at that point. I may very well say, hey, this person's doing a bang-up job, can you continue on? But it isn't an automatic progression. So the thing about trust is there's a lot of flexibility to them, and there's a lot of being able to decide how you want things to work.
I think there was a question over here.
Hope I get it right. So if you're living and you have your POA for medical, you have your PO for financial, and you go into the state of Alzheimer's or dementia, so now you can't make your decisions anymore, you have no living will. So POA ends after you pass, then what happens with the estate? Or can you set something up?
So if you don't have a will at that point, not a living will, because the living will has to do with when that last stage of life. the state has decided how things are going. So typically, I mean, there's a little bit of a difference, but as a rule of thumb, it goes to the spouse, then it goes to the kids. If there's no kids, then they go up to the parent. And if there's no parents, then they go to the other siblings. And then if there's no siblings left, they look to see if they had kids. And if there's no kids there, then they go up to your grandparents. And then they just kind of, it's like a tree. They just keep going until, and that's why you hear those like stories of, oh, I inherited money from my third cousin that I'd never met. It's because somebody died without a will and they truly didn't have anyone.
So that would all go through probate?
It all goes through probate.
Has any say of-
Right.
So once the person gets to that stage and they have the two POAs, whether it's the same person or not, is there anything you can do to set anything legal up, or because they can't make that decision, the family or the person in charge of the financial PA wouldn't be able to designate anything? Or?
No, they really wouldn't. I would say the only thing would be if somebody did have a durable power of attorney, but they never did a will. So they have a durable power of attorney. And if that durable power of attorney said that their power of attorney had the authority to create a trust, then that's what they could do. That durable power of attorney could create a trust, move assets into the trust, and then make the designations. But there have to be, as a durable power of attorney, you have a fiduciary responsibility, and you need to be acting in the best interest of that person. So if you know, we had conversations when he still had capacity, and I know he would want it to go to his two kids, and he would also want to take care of his niece, who had always been very good to him. Well, you're probably going to be fine with that. We always think it's better to have those documents in place when someone has capacity still, though.
Because there's always the likelihood that those are going to be challenged, particularly if there's someone left out who would have gotten through the laws of intestacy. They may very well fight that. So it's not ideal. Yeah, so it's not ideal. Ideally, you should have these documents ahead of time. Yeah.
Does a trust protect assets? So say they've been healthy and then they got dementia or Alzheimer's. Does it protect the assets if they end up having to go to nursing home?
No. There's different types of trusts, which I don't think we get into with this presentation. There's what's called revocable trusts, which are the ones that you have control over. You can put things in, you can take things out. They will be counted for Medicaid purposes. There's a different type of a trust, which is called an irrevocable trust, which is you kind of set up the guidelines, you put the assets into it, and then you're not able to control those funds anymore. Because the general rule of thumb is if you can control assets, the state of Ohio says, great, liquidate them and use them to spend for your care. So that type of a trust, and that's often what we're seeing that people wrestle with, because in order to truly protect those funds, they have to be out of your control. And a lot of people don't want to put those funds out of their control. But if you don't do that, then they can't be protected for Medicaid purposes. And there's a 5-year look back period for Medicaid.
And we may talk about it a little more here, but if not, we can talk about that some more at the end.
But also, if you have life insurance, my sister-in-law had to do this. Her mother only had like $8,000, but before Medicaid would help cover, she had to spend like $7,000 of it.
You're allowed to have $2,000 in countable assets.
And you're allowed to have a life insurance policy with a cash value up to $1,500. Well, it's hard to even find a policy with that.
Usually those are ones that like parents bought for their kids 50 years ago that they still have left around.
There's still some planning we can do, and sometimes what we're looking at doing with that is, if we have somebody with that situation, is you can actually often transfer that into an irrevocable funeral policy, so you buy a different type of, you can just transfer it as an insurance policy, and it gets irrevocably assigned to a funeral trust. It can be with a funeral home. We often recommend not. You can actually just do it with some of the insurance companies have these irrevocable funeral trusts, because you may think you're going to be buried here in Cleveland, but you end up moving to Florida, and then you have to deal with transferring that. And frankly, there's also been situations where people buy an irrevocable funeral policy with Brown Funeral Home, and Brown Funeral Home goes out of business and their money's gone. Doing it with just a pure insurance product that's not assigned to a funeral home, we think is a better way to go.
And going to the life insurance, it depends on the type of policy. So, for example, whole life policies have a cash value to it. So you can cash it out, even if it's not for the full value, the full death value. Medicaid will say cash that out. Term life policies typically don't have any cash value to them. So Medicaid doesn't count that because you can't cash it out. So that would be an exempt asset. So that's kind of the difference between them. Yeah.
And then the term life one, if you have that, the person passes, Medicaid can't take that money because it's used for their funeral.
Well, there's so many different ifs there. Typically, yes, or if it's named to go to somebody else, so there's an actual beneficiary named, then that's going to be exempt from Medicaid estate recovery. If somebody had failed to name a beneficiary and it just went into their estate, it would be subject to Medicaid estate recovery.
So paying for care, how do we meet our current expenses? These are the questions people are asking. What is the lowest level of care that might be needed? What is the highest level of care that might be needed? What financial resources do we have now that can pay for this range of care? And what additional resources might we need? And it's important to look at what level of care is needed. We have a lot of people who think, well, I could never put my mom in a skilled nursing facility. I'm not putting my mom in a nursing home, but I'll have her live in an assisted living facility. Well, if mom needs skilled nursing care, having her in an assisted living may make you feel better, but mom's not going to get the level of care that she needs. And there's different levels of regulation. There's different levels of education and staffing and oversight of these different types of facilities. And for many people, assisted living is great, but for some people, they need that skilled living.
We also, and I'm sorry, I haven't looked at these slides in a little bit, so I hope I don't get ahead of ourselves. Well, let's keep going, and we'll cover this again at the end if we need to. So how are we going to be looking at paying for long-term care? Income may come from your employment, as long as you're having income, as long as you're currently employed. Retirement plans, saving and assets. Sometimes we're looking at reverse mortgages, but there's some real concerns with those. And then there's long-term care insurance. If you got that a while ago, if you're looking at somebody who has a dementia diagnosis, they're not going to be getting long-term care insurance at that point. So reverse mortgages are designed to help those 62 and over, and they're able to convert the equity of their home into income. There are some advantages. Social Security and Medicare benefits are not effective, and there's no income requirement or monthly payments. However, money received is tax-free and can be used in any way, but it may affect your eligibility for other programs. If you're thinking that Medicaid has to be part of your planning, and all of a sudden you get a reverse mortgage and you cash out and have a big lump sum, well, now you may not be eligible for Medicaid anymore. It might be better to keep that asset in the house, or keep in the house. Closing costs and service fees can vary, and sole homeowners who stay in assisted living or nursing home for over a year must repay the balance of that loan, which can result in a loss of the home. So sometimes people think, I'm going to get a reverse mortgage, and then they end up in an assisted living. Now they have to sell the house in order to pay back that reverse mortgage. So long-term care insurance. And again, this is a great thing for people to be thinking about ahead of time. If you're in your, even 30s, 40s, 50s, talk with somebody about whether long-term care insurance might be a good option for you. And it's funny because a lot of times people say, I don't want to get long-term care insurance because what if I pay all this money into it and I never use it? It's going to be a waste. Well, that's the same if I buy homeowner's insurance and my house doesn't burn down, or I buy car insurance and I don't get into an accident, knock on wood. Hopefully you won't need to use it, but if you do need to use it, I'll tell you, we have clients come into our office to do, start doing some long-term care planning, and we ask them if they have long-term care insurance, and we had some woman who, she was like, I got it, and it is $250 a day for the rest of my life. I made sure it was for the rest of my life, and we're like, fantastic. She didn't need to, I mean, we still did planning for her, but she didn't need to worry about Medicaid asset protection planning because she had done that planning ahead of time. Other times it may be $150 a day and it's for 2 years, or $150 a day up to a maximum benefit of X, Y, and Z. So it really varies based on the policy when you get it. One of the other things, though, that is worth talking about is even if maybe you're older that would be able to get a traditional long-term care policy, there are some really great new insurance products where it's a whole life insurance policy with a long-term care rider. So you invest in that, and if you needed it for long-term care insurance, great, you can use it to pay for long-term care. But if you never use it, then you have named beneficiaries, and it's a way to leave things for your beneficiaries. So those can be really good options for folks who still think that they'd like to do some planning.
So federal tax deductions. There's certain things that you may be able to deduct taxes on: personal care items, home improvements, in-home care, nursing services, assisted living, and nursing home care. Those first items too, those are all things that you can spend money on, and they're allowable spend downs for Medicaid. So you can spend money on those things. State tax deductions and credits vary from state, but again, may include medical expenses, long-term care insurance premium, tax, caregiver's tax credit, and child and dependent care. We're not going to watch that.
The reality is, for a lot of folks, this is where it starts. We're looking to our family members to support us. We're looking, friends and neighbors. Folks who are active in their faith community may find support there. And there's great volunteer groups. And again, the Alzheimer's Association is a great resource for this. There are often in every community, there's support groups that you can find help as well. There's the Older Americans Act, which authorizes funds for those supportive services, and the other things that are discussed here. So, Medicare versus Medicaid. This is often very confusing for folks, and we often have people come into us and we're talking about planning, and we say, so are you getting Medicare? And they say, no, I'm getting Medicaid. And because I turned 65, I started getting Medicaid. Well, it doesn't help that they name them practically the same thing, but we're going to take a little bit of time to talk about the difference. So Medicare is what most folks, when you turn 65, are able to get, and some folks may be getting it earlier for various reasons, but for the most part, it's 65, and it's a government insurance program. It's age-based, it's administered at the federal level, and it does not pay for long-term nursing care, other than one very, very small exception, which I think may be on another slide, so I'm not going to talk about that now. Medicaid, on the other hand, it's again, government assistance program, but it's needs-based. It's administered by the state. So where Medicare is going to be pretty much the same across the country with a couple of exceptions, Medicaid is different state by state. And frankly, in Ohio, it's different county by county, which is fun when you practice in this area of law. Medicaid is often what we see folks needing to use in order to pay for long-term care.
So Medicare. Medicare is a federal insurance policy. Again, it's people typically over 65, people under 65 with certain disabilities. So if people are on disability on SSDI, after 2 years, they can be eligible for Medicare. And people of any state, at any age with end-stage renal disease. Some of these things, as you start reading these laws, you can tell which organizations had better lobbyists than other organizations. I've decided that I think the blind must have the best lobbyists. But Medicare Part A is hospitalization. Part B is medical insurance, going to doctors and such. Part D is the prescription drug coverage. And then there's different Medigap and other types of policies. So what's covered under Medicare? Inpatient care in hospitals, skilled nursing care for short-term rehabilitation. And I don't know, I'm going to say it now since I'm not sure if they have it. So it will pay for up to 100 days after a 3-day admitted in a hospital. And that 3-day is important. It's not you were there for 3 days, but 2 of those days you were there under observation. You have to be admitted for 3 days. And so at that point, they will pay for 100 days in a skilled nursing facility for rehab, but it's not 100%. So for the first 20 days, it's 100%, and then there's a pretty hefty copay for the remainder, for that last 80 days, and then at that point, it's private pay. Home health care and hospice care are covered. Again, automatically signed up at 65, under 65 if you're receiving SSDI for 24 months. Most cases, there's no premiums, but there are often copays, coinsurance, and deductibles. So, SS social, yeah, it's disability. So it's not needs-based, it's based on your work history. What's covered? Part B, physician services, outpatient services, labs and such, durable medical equipment, and some preventive services. So a lot of people pay that monthly premium. You see, what is it, $134.50, $135.50, somewhere in that range. So what's not covered under A and B? Dental care, dentures, cosmetic surgery, acupuncture, hearing aids, which I just don't understand for the life of me, long-term care. Part D is the prescription drug coverage. So it covers or lowers the cost of outpatient prescriptions, can help protect against higher costs. How it works. A penalty is assessed for not enrolling unless proof of an alternative coverage is provided. Some people, when they turn 65, are still working. They don't need to get it at that point. Part A and B are required, and again, there's variations in costs.
So these are newer products, the Medicare Advantage plans. They're an alternative to Medicare, and a lot of folks are really being kind of encouraged to switch to these Medicare Advantage plans. We're really hearing mixed things, and we're actually hearing for folks who may end up needing that long-term care, being on an Advantage plan can really be, can be a disadvantage.
It depends on the plan. It varies.
So I think it's important to look at what the different plans are. Some folks, if you're on a good supplemental plan and you've been on that supplemental plan, just because somebody comes along and tries to sell you on an Advantage plan, consider it. And frankly, I'd even consider reaching out to your doctor's office because the Advantage plans have been around long enough that if you have a doctor who's responsive or his staff is or her staff is responsive, you may well hear somebody say, no, don't do the Advantage, or they may say, we've had no problems with Advantage, but it's worth having a conversation with your healthcare providers, not just the person who's trying to sell you the policy.
And looking at what you need. What are the procedures that you need? What are the doctors that you need? Because it may vary depending on what your individual needs are.
This is
OSHIP.
OSHIP. This is a good place to get information on the different policies. So Medigap, and this is Medicare supplemental insurance. Again, this is what has been more traditional as a supplemental.
Oh, sorry, I just skipped over that.
You sure did. So again, not used with Medicare Advantage. It's usually an either or. And those one of the nice things also about the Advantage plan, not the Advantage plans, the supplemental plans, where Chris was talking about if somebody is hospitalized for 3 days and they do get that 100-day of coverage under Medicare, first 20 days is 100%, and then after that is the significant copay. These supplemental policies will often cover that copay, so that's a huge difference.
So what is Medicaid? It's eligibility based on 1, medical need, 2, income and assets. So the payments don't go to the individual, they go directly to the care provider. This is often when people don't have funds, this is what's used to pay for nursing home care, long-term care. And there's different programs, home and community-based long-term care and CHIP. So low income is only one factor. Right now, I think it's 3130 is the amount, 3,000. I'm thinking of, well, how much is the income amount this year? 2313 or 2330. 2,330 is how much you're allowed to have in income. You can spend down with caution. The state Medicaid offices, departments of welfare, departments of health. Typically in Ohio, it's the the county departments of jobs and family services are the ones at the county level who deal with Medicaid. When researching nursing homes, ask whether Medicaid is accepted. Not all nursing homes do. Nursing homes, though, if 1 bed is Medicaid, they're all Medicaid beds for nursing home, for skilled nursing facilities. For assisted living, they don't necessarily have the whole facility. They may have individual beds or a certain number of beds, which is often why you see assisted living facilities say that you need to privately pay for 24 months and then you will be eligible to apply for Medicaid. They can't do that at skilled nursing facilities. They can't do it at assisted living facilities. Again, does the person need to privately pay? And what does happen when the person's resources are depleted?
You want to go back for 1 second, though, because I do think we want to talk there for just a little bit. When it looks, we always think it's important to think about doing Medicaid asset protection planning. There are things that we can do at various stages. You've probably heard people talking about you have to do some planning 5 years out before somebody needs to apply for Medicaid. And that's true that if you're able to do planning 5 years before applying for Medicaid, folks can transfer assets such as to an irrevocable trust. And if it's 5 years before somebody needs to apply for Medicaid, pretty much all those assets can be protected. It's allowable under state law, and it's a good way to make sure that you're preserving assets. They can no longer be controlled by the person whose funds they are. But often what we'll see is a loved one is named as the trustee, and that trustee can take those funds out, and the trustee is then allowed, it's distributed to a lifetime beneficiary, again, such as often a child. And that child can then spend those funds on whatever they want. And that includes if they're needing to help with mom or dad, they can do that. Mom and dad can't force them to do it. They can't be obligated to, but the child can certainly choose to do that. Because when we're talking about Medicaid, for somebody to be eligible and to receive Medicaid, all of their income other than $50 gets turned over to the nursing home. So for the rest of their life, which can be a couple of years or it could be many years, $50 a month is all they have. So when we're able to do that planning 5 years out, then those funds are things that their loved ones can use to help supplement their parents for the rest of their lives. When we haven't done 5-year planning, sometimes you didn't know that you were going to need to do planning and you can't get 5 years. There's still a lot of planning that can be done. There are certain tools such as Medicaid compliant annuities where we may do a transfer which is going to create a penalty, but we're able to pay through that and still be able to help supplement what the parents or the loved ones may need over the course of their life. The reason I wanted to talk about this here is sometimes what happens, and we hear this sadly a lot, is we have a loved one who's ill, they're going and talking to a nursing home, the nursing home asks them how much assets they have, and maybe they're married and they have $150,000 in cash assets, and the nursing home says, well, that's no problem, you just keep paying us monthly, and when you get down to $2,000, we'll apply for Medicaid. Well, that's not right at all. Because in fact, a spouse is able, a community spouse who's still in the community can keep half of the assets up to $126,000. So that couple could have saved, without even doing any irrevocable trust planning, a significant amount of assets. And if they just listen to the nursing home, boy, they're spending everything down, and then they show up, and at that point, it's too late. Those funds are gone. So that's planning that needs to be done ahead of time, and there are some nursing homes, there are some very nice, good nursing homes that same person would be told, you should go talk to an elder law attorney because they can help you do some planning. But there's others who just say, just start writing the checks and we'll help you when you're down to no funds.
My friend, her father just passed, and so they were dealing with the hospital and trying to, before he passed, they were gonna put him into a nursing home. And they said, well, if your mom doesn't have the money, we're just gonna investigate all you kids, and if you have assets, then you can just pay for it. And the kids were like ready to kill this person. They can't do that?
No. Well, here's the thing. No, as long as the kid didn't, out of kindness from bad advice from the nursing home, sign a form accepting personal responsibility. So they absolutely should not do that. But if mom has no funds and it's a reputable, honorable nursing home, and we work with some that are wonderful, we really do, they would say, no, that's fine. And often if it's a situation where there are a small amount of assets, maybe we've got $10,000 in assets, and other than that, mom's eligible for Medicaid. Well, you know what? We can get an irrevocable funeral policy, so that's going to pay for the funeral, which it's going to need to be paid for. Mom's funds are under $2,000 now. The nursing home will accept them as Medicaid pending because they know they're going to be accepted for Medicaid, and nobody is paying anything. And a facility that said that to them, that's really scary, and that's really sad. I'm sorry to hear that. It is.
So veterans benefits, and often we're talking about a certain type of what they call the VA pension, which is, it's often what you'll hear is this aid and attendance benefit, and it's for veterans of wartime veterans and the spouses of wartime veterans, the widowed spouses of wartime veterans. And so there's a certain regulations that, they have to have served during a war, one day during a period of war. And the government says this is, for example, World War II is December 7th, 1941 through, and they have it ending at December 31st, 1946. So that's actually a year afterwards. But anyone, as long as you served one day during a wartime, you would be eligible. If you are other than dishonorably discharged. So if someone's dishonorably discharged, they're not eligible. But there's about 5 different ways that a person can be discharged, and it's only dishonorable is the one that knocks you out of it. And you also, other than a small window before Vietnam, you don't have to have served in the arena of war. You could have been in Fort Bragg the whole time. As long as it's during that period, you would be eligible. And so funds can be used to pay for unreimbursed medical expenses. And unlike Medicaid that gets paid to the provider, these VA benefits can get paid to the individual to be used to pay for their care. And I was just going to say, so it's for, right now it's a little over $1,800 for a spouse or for a veteran. It's a little over $2,100 for a veteran with a spouse, and the spouse can get about a little over $1,200, I think, right now.
We get a little evangelical about these because these are a benefit that these folks who served as in our military during a period of wartime, they deserve these benefits. And unfortunately, a lot of people don't even know they're there. And sadly, we'll hear something where, somebody's dad passed away and he was in assisted living and the kids were all chipping in to pay for it for the last years of their life, and they didn't even know this benefit was available. So we always like to encourage folks, if you know folks who do have a loved one who served during a wartime period and they're having health issues, they should find out whether they're eligible for aid and attendance benefits. This is something that attorneys can help with, but one of the important things with aid and attendance benefits is attorneys can't charge to help with nobody can charge to help with the application. Now, often if somebody's coming into us and we're doing all kinds of estate planning for them, we're charging for, the work we're doing. But what we do to help somebody apply for aid and attendance, there's no charge for that, which I think is nice. It's a way to look out for people who looked out for us.
Is there a financial need?
There is, but it's a lot less draconian than it is for Medicaid. So for Medicaid, for an individual, you're usually looking at, they can only have $2,000 in assets. If a couple is both applying at the same time, they can have $3,000, and there's the community spouse issue as well. For VA aid and attendance, you combine income and assets, and the limit for that is $126,000, and you're not counting a car, you're not counting the house. So you can have somebody who has a house and they have $50,000 in cash and income, that puts them at $100,000, and they can still be eligible for these benefits, and they can make such a huge difference. And as we said, because it gets paid directly to you, so if it was my mom who was eligible for these benefits, she would get that check and she could use it to pay a home health care worker who's coming into the house, or say my sister, our other sister, has quit her job to help take care of mom. She can actually use those funds to pay my sister. You can't use it to pay a spouse, but you can use it to pay a loved one. Now there's going to be some complications with that. You're going to want to make sure taxes are being paid, that you're tracking hours. That's something to talk with somebody about if you're at that point. But a lot of times you do have loved ones who are quitting jobs or working less hours to take care of a loved one, and if this can help make that possible, well, that's a great thing.
And what they end up doing is they kind of do a equation, and they look at the unreimbursed medical expenses and what the income is. So it depends on if there's not a lot of unreimbursed medical expenses, they may not be eligible. But once you start accruing some of those medical expenses, it may be an option. Employments, what are essential functions of your job, what's still easy to do, what's difficult, and are there any kind of accommodations that can make work still possible? And you should explore your benefits. You should find out if your company has long-term disability, short-term disability, any kind of long-term care coverage. All of these items are things that you're going to want to people who are still employed, talk to your HR person and see what those options are.
And going back one second, it's also something, especially the Family Medical Leave Act, when we see a loved one, a caretaker who is taking care of their loved ones, sometimes that's something that they're using. They're using the FMLA in order to take time off from work in order to take care of their loved one. So it's something that it's good to talk to your employer about.
So again, keeping the communications open with your employer, find out what those accommodation options are. Sometimes you may need to provide some documentation from physicians. And, at that point, it may be necessary to start planning next steps. We're not going to do that.
Unfortunately, we do see younger onset dementia and Alzheimer's, and there we may be looking at security disability benefits. So again, that's that SSDI we were referring to, and that's something that anybody may be eligible for. You don't have the same strict financial requirements. It's based on how much you worked, how many hours, or how many quarters you worked. I'm about to cough. I'm going to let you talk.
So we often say that, for example, Mark Zuckerberg of Facebook, if he met the description for disability and couldn't work, he'd be eligible for SSDI. He would never take it, but he'd be eligible. Eligibility is based on your age and disability. Oh, no, this is SSI. This is different. So again, they'd like to make it difficult by naming them almost the same thing, but different. SSI is if you don't have that work history. So often people who are disabled and can't work, they would be eligible for SSI.
We're disabled as children maybe, and
Right.
never really had a work history.
Thank you. So again, age and disability, income and assets, those all go into consideration.
But these are really low benefits. We're at what,
771, I think, right now is
month.
a month is what is able to be used. The disability criteria is the same, but the employment history is different. For the most part, SSDI, the one that's based on your work history, after 2 years, Medicare is the insurance policy that correlates with that. SSI, which doesn't have the work history, that Medicaid would be that would be the medical program.
No.
We don't care. Oh, and these are the various organizations.
And really, if you haven't been on Alzheimer Association's website, you really should check it out. They have a lot of great resources, both locally and nationally, and they have a lot of great events like this where you can get lots of information.
That's it.
I think that's it, but we'll open up for more questions if anyone has any other questions.